Hey everyone, for those of you I don't know, my name is Hirsh Jain, and I'm the Director of Market Intelligence for Verdant Strategies, which is your trusted financial services partner for the cannabis industry. And we're all super excited for the discussion that we're going to be having today about Todd Blanche's rescheduling order last week. I'm sure we're all trying to make sense of it, and we're excited for this discussion today. I'm really happy to be joined on this webinar by my co-panelists, Rachel Wright, who is the CEO and founder of Verdant, and Ian Rassman from Chosen Payments. I'm going to ask both of these folks who I love to introduce themselves here in a second, but I'm going to take a few minutes at the top of the webinar, and I'm going to give everyone an overview of the topics that we're going to be discussing today. We really want everyone to have a roadmap of the different topics in your head. I'll give you that few-minute overview of what we're going to talk about, and you can take notes, reflect on that, and anticipate what we'll discuss. The first topic that we're really going to dive into today when it comes to the Blanche order that was issued last week is, what does it mean for medical cannabis to be Schedule 3? Is this final that this order was issued? Could it be susceptible to legal challenges? That's one question we're going to ask. The second question we're going to discuss is, how does this impact 280E? We've heard that 280E is going away for medical operators and might even be retroactive. So we'll talk through the scenarios there on how far 280E goes back. Number three, we'll talk about this DEA registration portal. I'm sure some of you know that it went live today, and there are already people posting online and posting press releases about how they've submitted their applications. We'll talk about what is that portal and what are the mechanics there. The fourth issue we're going to tackle is interstate commerce. I'm sure you're hearing a lot about how medical cannabis is now federally legal, and so there can be commerce between compliant medical operators in different states. We'll unpack that a little bit and what it means, what the timing is, and what some of the complications are. The fifth topic we'll talk about is international commerce. We've heard that there's language in the order that allows for exports. What does that mean in practice? What does it look like for a U.S. operator to export? What are the details and the complications regarding exports? And then we'll round out our discussion of medical cannabis by asking ourselves, okay, so if medical cannabis is legal, technically, can a purely medical cannabis company, if it's registered with the DEA, can it avail themselves of the benefits of legal businesses? Could it potentially list on a major stock exchange? Could it obtain an SBA loan? Does it have access to bankruptcy protection? Does it have access to IP and trademark protections? Can it be acquired by a non-cannabis entity? So all of these really big and weighty questions. That's the first topic. The second thing we'll talk through is on the adult use side. We got this order regarding medical cannabis, but we also know there's going to be this adult use hearing that runs from June 29th to July 15th. What is that hearing about? After that happens, how long are we going to be waiting before we find out what happens with adult use operators? What does 280E mean for them? We'll talk through the stuff on the adult use side. And then from there, we'll talk through what applies to folks in this room, which are dual operators. If you hold both medical and adult use licenses, what does that bifurcation mean from your business? How do you need to prepare your books so you can distinguish medical from adult use activity, right? Is my state going to make it easier for me to be a medical operator so I can qualify for these benefits? Does the medical adult use distinction, does this just speed up the day where that distinction goes away or not? We'll talk through those issues that I'm sure that are on your mind. And then the final topic that hopefully we have time to get to today is, what are the implications of rescheduling for things like state level reform? So for the 10 states that don't have medical programs today, what does this rescheduling order mean for them, for South Carolina or for an Indiana or a North Carolina? What are its implications internationally, given that the rest of the world pays attention to the US moves on drug policy? What have other countries around the world started to do even in the past week here? So to summarize, we'll talk about the medical cannabis order and all of those relevant details. We'll talk about the adult use hearing and the timing there. We'll talk about these dual licensees and how they're going to make their way through taxes and other issues. And then we'll talk about the state level and also the international implications of this really historic rescheduling order. Thank you for allowing me to go into depth there. I hope that really gives you a sense of all of the really juicy things we're going to walk through. And with that, I'd love to pass it over to Rachel.
Great. Rachel Wright, CEO and founder of Verdant Strategies, CPA and financial firm serving the cannabis industry for over a decade. I see a lot of our friends on this call, operators and service providers alike. I just want to say first, thank you so much for everybody for being here. Second, Hirsh, 6:30 that morning, you and I were on the phone. Thanks to Rose, who's here, and she sent me the news wire of rescheduling for medical purposes. And I immediately called Hirsh. And then we hopped on the phone with some clients and he was reading through the regulations. And I just want to say thank you so much for your dedication and reading all these regulations, fielding all the questions, being there for people. Thank you very much. And Ann, we love Ann too.
Wow, thank you so much. And thank you, Rachel, for having me here. Hirsh, really thrilled to participate on this panel with you and all of your knowledge. For those that don't know me, my name is Ian Rassman. I've been working in the cannabis industry for over a decade with over 6 years of experience working internationally. During the day, my day job, if you will, is I'm a payments guy. I lead Rassman payments for dispensaries, for e-commerce, really anything that's high risk related, focused on cannabis for more than 10 years now. My volunteer roles, you may know me from with Normal, advancing advocacy, and then you may also know me from the Cannabis Chamber of Commerce, where I'm the executive vice chair. And I have been focused on expanding out this global networking organization across the globe. That's a little bit about my experience, lots of international, lots of banking and payments experience, and that's where I'm coming from.
Awesome. Thank you, Rachel and Ian, both for those great introductions. With that, we'll dive into the discussion. The first topic we're going to unpack today is, okay, so Todd Blanche, he signed this order saying that medical cannabis is now Schedule 3. What does that mean? Here are the things that I'm really excited to talk about, which is this final, or could it be subject to legal challenges? Number one. Number two, what are the 280E implications of this for medical operators? I'm excited to talk about also the DEA registration portal that went live today and some of the other issues we talked about, like international commerce and interstate commerce. I just listed a bunch of topics there, and I'm happy to provide my opinion on them in a second. But before I do that, I'm just going to open up the floor to Rachel or Ian to comment on any of these topics that they would like to. Obviously, you guys don't have to hit on all of those topics, but I thought I would just give each of you the floor quickly to see if you've any reaction to medical cannabis being Schedule 3. And then after that, I'm happy to chime in with some of my opinions.
I guess what I'd say is it's really the states that are medically licensed states, like Florida is one of those states that I particularly think of. Those are quite simple, I think, to navigate. Hirsh, correct me if I'm wrong, but that's how I see those. It's the states such as California that are a little bit more nuanced. And I see some questions coming in here. Chris Anderson, I don't know if you're here from Redwood Roots. He asked, do we think there'll be any 280E tax relief for recreational operators? Obviously, that's in California. So these are the kinds of things that we need to think about for states such as California. And then another thing we need to think about are local jurisdictions. So we've got some folks in here from City of LA where not only is there 280E, but we also think about things in California on the local level. So City of LA has recreational and medicinal. Then we have some MMIC questions, which are the types of cards that you can apply for with the state of California to obtain the patient recommendations. So obviously in states where there's multiple jurisdictions that the states may offer both medical and recreational licenses. And then you look to the local jurisdictions. Can we slice it and dice it just even a little bit more based on those local jurisdictions? What does the language say? Can we break it up even further? Is there some gray area to be read within that? So that's definitely something to think about. I'd also consider that, yes, right now we're looking at medical. Mostly recreational is just around the corner. Hopefully, fingers crossed. That's what we're hoping. We have a few months. So those folks that are purely recreational or adult use plan for the future, but let's hold on for a few months.
So I think Rachel raised a bunch of great questions, and a lot of them were mentioned in the chat. So I'm going to try and tackle a few of them right at the outset. Here's the first thing I think we should be talking about, guys, is like, is this order final? We have heard a bunch of times like, okay, the Justice Department might do something, but it's always subject to litigation. So here's my answer. Technically, it is a final order, but at the same time, these things can always be legally challenged. But I think one important thing is that the DEA registration portal opened today. So today started the process by which folks started formally registering with the government and paying registration fees. And although these orders are always subject to legal challenge, once the government machinery starts working, then the program becomes much more embedded in government structure. So I think that's just an important thing to pay attention to. As this system gets moving and as a government infrastructure is built around this program, then we can see it as being on much more solid ground. That's number one. The second thing I wanted to talk about here was 280E. Again, here's the important things to know. Medical cannabis, now being Schedule 3, is no longer subject to 280E. And I know we all know this, but just spelling it out really clearly, 280E is applicable to Schedule 1 and Schedule 2 drugs. So the important thing is that medical cannabis is no longer subject to 280E. So that's a big win for operators that derive a lot of revenue from medical cannabis. The second important thing to be paying attention to is this idea of retroactivity. I'm sure you guys all saw in the order, the Attorney General said 280E is now gone, But in addition to that, we encourage the Secretary of the Treasury and the IRS to consider whether retroactive relief here is important. I think that's a really important detail to pay attention to. If you think about the government power structure that works here, the Attorney General actually does not have the power themselves to say we're going retroactively by 2 or 4 years. But what they're saying is that the Department of the Treasury and the IRS is going to provide some guidance there. I think the really important thing for everyone to take away is if you're trying to understand how far back 280E repeal and retroactivity goes, you want to be paying close attention to the guidance that will come out from the Department of Treasury and the IRS. Some of you may know that last Thursday evening, they actually sent out a press release. And if you haven't seen this press release, we can send it to you after the call. This press release basically said, we saw this order from the Attorney General. We're still thinking through the tax implications, further guidance to come. So I actually think that's really encouraging, right? These are the different branches of the government that are communicating with each other and are telling you there's going to be more clarity coming soon. As soon as we have that, we'll obviously share that with all of you, but that's something you should be paying attention to. A couple more points I'll make. People are asking the question, if this is retroactive, does it go back 2 years or 5 years or 10 years? And I think, as we know now, medical cannabis in California goes back to 1996. So until we get clarity, at least it's theoretically possible that medical cannabis operators could get a 280 refund going back 5, 10, 15 years. Is that realistic? We'll have to see. But I think that's one of the key things we're going to be paying attention to, which is how far back it goes. And I'll note just one more thing on this issue, which is that there are some people who have historically not been paying their taxes to their 280E taxes to the IRS over the past few years. And what they have relied on is the HHS memo that came out in 2023. So there's a legal theory that said the Department of Health and Human Services, which is the branch of the US government that is responsible for making a determination about whether cannabis has medical utility and whether it belongs on Schedule 3, that they came out with a memo way back in 2023 that said, we did this study of all these medical programs and we issued this 252-page report, and cannabis has medical utility. So I'm only pointing that out because that is a relevant date to pay attention to. Some people argue the moment where the US government formally recognized the medical utility of cannabis. So we'll have to see the guidance that's coming out from the IRS, but I think it's notable that everyone understands that memo came out in August of 2023, and there's a lot of taxpayers that are using that as the moment where they believe these taxes are no longer applicable. That doesn't mean the IRS will agree, but I think that's something that folks should be paying attention to. The last thing I wanted to say on medical cannabis, I think it's important that everybody understand that the DEA registration portal opened today. It opened about 4 or 5 hours ago, and that's the process by which compliant medical operators are going to submit an application and be properly registered with the DEA so they can take advantage of these tax benefits. Just a few important things that I want to mention. One, the order says that you have 60 days from the order in order to complete that DEA registration. So some people on the line are thinking through, do I do this? Do I not do this? Know that you have some time, but not infinite time. So that's a decision you're going to have to make by June 22nd or so. That's number one. Number two, I want to point out in the few hours since this portal has opened, there's a bunch of operators that have completed the process. I just saw like a very well-known MSO that put out a press release about them kind of completing the process. And there are people that have a receipt that say I was the 37th person to register. So just know some people are completing the process. The last thing that I want to acknowledge is that there's some pretty detailed questions in that registration portal that talks about the people that are responsible for handling this cannabis and whether the business has ever handled cannabis without having the necessary permitting, which is obviously all businesses in cannabis. As we think through when you want to complete this process, just know that it's important for you to just first review the questions to understand what's going to be asked here. I'm actually going to pause for a second and let Ian chime in with any thoughts he wants to add.
I'm going to double down on the first thing Rachel said when she came on the call, and that was, who's excited about rescheduling? And I'm going to say that there's a lot of excitement about rescheduling as we all figure out what it means. But I would say that this is a global moment because when the US makes moves, the world pays attention. Now, it doesn't automatically follow what we do. We all know that, but it is paying attention. The US is still the most influential reference point for global drug policy and capital markets. Schedule 3 is a very clear signal to regulators, investors, and institutions worldwide that things are changing here in the US. But each country moves at its own pace based on local politics and frameworks. And certainly more of the world is embracing medical cannabis than adult use cannabis. And that's specifically true in Europe. They're all focused on the medical. I think this is going to have global ramifications, and we shall see what those look like as time goes on. But the world is watching us right now in this.
Great. Thanks, Ian. So just to recap on some of the things we've learned so far, we think this order is final. There could be legal challenges, but the machinery of the government's already working. So that's pretty good news. We've learned number two, 280E is going away from medical operators. There's an open question about how far back it's going to go. Again, now we know that guidance is going to come from the IRS and the Department of Treasury. And we also know maybe one hypothesis is that it might go back to when the HHS memo came out in August of 2023. And we also know that the DEA registration portal is open. And so if we're interested in submitting the application, which you would need to do to be compliant with the DEA, the first step is just to take a look at that set of questions. And I'm sure that's an ongoing conversation that we can have. The next topic that I wanted to dive into, guys, is this idea of interstate commerce. I've seen a lot of chatter about this online. We got some questions about it. And look, we could spend this entire hour talking about interstate commerce, but I'm going to try to do my best to summarize it for you. The first thing to know is that it was quite interesting that CANRA, which is the Cannabis Regulators Association, put out a press release earlier this week suggesting that interstate commerce is possible. I think that's just one interesting data point to note, that the group of cannabis regulators put out a press release summarizing these developments, and they said this could, and they were very careful with their language, but they said this could open up interstate commerce. That's a useful data point, and we're going to get into the complicating details here in a second. But it's notable that these state regulators gestured in that direction. I think another important detail for people to think through is, what state am I in? Am I in a state that has gestured an interest in engaging in interstate commerce? To provide one example, if you're in California, people may remember that 4 years ago, September of 2022, the state of California passed a bill called SB 1326. And this was a bill that authorized the governor of California to enter into a compact with other states to engage in interstate commerce. So this didn't allow interstate commerce writ large, but just note that there are some states like California where the governor has the authority to enter into an agreement with another state if they also want to engage in interstate commerce. Now, again, that's a lot of work that needs to be done to come to that formal agreement, and that suggests that one state has to pick a dance partner with another state and decide whether to dance or not. It's not a full-blown interstate commerce, but I think that's just one notable data point when you think about your state and their posture towards interstate commerce. A few more points that I think are important to note here. We have this law that says medical cannabis is now federally legal. It's Schedule 3. Some people might say, okay, it's a federally legal business, and so on all other federally legal businesses, I drink my orange juice with the oranges grown in Florida. So same thing, right? It's a little bit more complicated than that. Number one, it's important to note that a lot of state laws still prohibit the intrastate transfer of cannabis products. So yes, you have this new federally legal business, but it's important to know that you probably live in a state that still says that it is not legal for you to engage in cannabis commerce with other states. So that's an important thing for you to know. There are those state laws that are still on the books. Then the question becomes, what does it take to change those state laws? And here, I know this is a little boring, but you really have to pay attention to your legislative calendar. If you think about the state of Virginia, for example, they have a legislative session that wraps up in April of every year. Their legislative session just ended. The state of Virginia is not making any new laws until they come back in 2027. If you think about the state of Texas, for example, they actually have legislative sessions every other year, in 2025, in 2027, in 2029. I know this is like the boring government stuff, but just keep in mind that a lot of state laws still prohibit the interstate transfer of cannabis, and those state laws are still on the books. And even if everyone in the state wanted to change them, you can't just snap your fingers and change them overnight. There's a legislative calendar there. And look, we don't have time to get into every state's legislative calendar today. We're just surfacing the really important questions that you should keep in mind. So that's one piece of it, changing state law. Then the next question becomes, even if the states don't change their laws, couldn't legal challenges be put forth to challenge these prohibitions on interstate activity? And that's an interesting idea. I'm sure many folks on the call have heard of the Dormant Commerce Clause, which basically says, look, for a legal business, you cannot restrict commerce between the different states, the same way that I drink orange juice from oranges that were grown in Florida. And here, I think it's really important to pay attention. So you will hear smart legal minds properly describe how the Dormant Commerce Clause means that interstate commerce should exist. but it's a question of timing. And I would just note to everyone on the call, sometimes it takes a really long time for cases to wind their way through a court system. Just to give you one example, the state of California, about 6 months ago, a judge ruled that the metric system was not fulfilling its legal obligations when it came to track and trace. But we're still living under metric today. So a court might issue a ruling, but that does not mean things are going to change overnight. I think if you think about what we've talked about so far, we're like, okay, we might need these state laws to change. They're all on different legislative calendars, so I should probably be familiar with what the legislative calendar in my state is. And even if there are legal challenges to these state laws, it might take a while. We might be talking about interstate commerce in years, not months. I think it's important whenever you hear an artful legal theory about how these laws are going to be upended, remember the court system takes a while to wind its way through the process. A few more things that I'm going to mention. We should think about the mechanics here. California has a set of pesticide requirements, for example, that is different than the pesticide requirements that exist in other states. If you're in California right now, you know that the DCC has just spent many months revising its action limits for pesticides and adding new pesticides to the list. It is said that this is an important enough topic that we really need to get these action limits right. Those requirements vary dramatically by different states. Will some state regulators have a claim that in order to protect the public health and safety of my residents, you need to adhere to certain standards? And again, if you really want to be a legal nerd about this, I would point you back to that bill, SB 1326, that passed in California about interstate commerce. If you really read the bill, what it says is a governor will come to an agreement with another governor, and they're going to spend 6 months deciding what the pesticide requirements are going to look like and what the packaging requirements are going to look like. So just know these regimes are run very differently in different states. And so it's not like it'll be seamless, right, for whether it's packaging or pesticides, for all those things to be aligned on. We should consider, right, the impact that an interstate market would have on the regimes that exist in different states. So Rachel mentioned Florida before, right? Right now in the state of Florida, there's a very strict vertical integration requirement. Like Trulieve and Cureleaf already cannot sell to each other. So imagine a court ruling that said a California operator could sell to a Florida operator. How does that impact a Florida licensing structure that prohibits its own in-state licensees from engaging in commerce? That's a complicated question. And then another comment that I'll make before I summarize all of this is that if the medical programs essentially become a backdoor to interstate commerce, and then all of the adult use operators become medical operators as a result, have we just created an interstate commerce regime overnight? Will you really be able to keep it siloed to these operators? So to summarize all this, the point of all these observations is not to say that interstate commerce won't happen. I think it will happen, but I think this is all a question of timing. And sometimes we can get excited about a legal theory, but it's a big difference about whether this is going to be happening in a month or in a year. There's a very strong legal argument that a federally legal business should be able to engage in interstate commerce with federally legal businesses in other states, which is what these medical cannabis businesses are. But let's not underestimate the complications associated with doing so. The legal process by which state laws are challenged, the judicial process by which court decisions are made, the alignment on pesticide and packaging requirements, how this impacts different state level regimes. So just know, as you plan to build your interstate empire, you should keep in mind all of these potential roadblocks and minefields that are going to be really relevant to how this activity develops. My prediction is that the floodgates are not going to open overnight, that this will be an iterative, incremental approach, and we might see it take place in some states before others. And I think we should all be mindful of that.
That was great. Thank you so much, Hirsh. And I would say the caution to make any major moves, a lot of people are trying to make some major moves for some very minor output. So in those mixed states, mixed jurisdictions, should we change our POS systems? Should we even really be worried about minor medical changes if we're not in a fully licensed medical state? And I would say, let's just hold off. Let's wait a few months. Let's see what happens in July. A lot of folks that have actually asked me about the 280E implications, I personally know them, and I know right now they're not actually paying any 280E related taxes. So what I would say is to the folks that are not actually paying any federal 280E taxes, if there's a problem and you're not paying federal 280E taxes, it's not a tax problem. It's actually more of an operational and efficiency problem, and it's a business practices issue that we have to deal with. It's not really a tax problem. This is not going to save the industry overnight. I would definitely caution that. Don't make any major changes if your medical sales are minor, and then if you're not paying 280E, and we're still having problems, it's a different problem. So we got to get down to the root cause of that issue if that's the case. Additionally, what I wanted to touch on is as we're talking to operators in those medically licensed states, the next question is, say they're a producer or they're a cultivator and they have tons of extra flower and they've had issues with additional supply on hand. They say, okay, now maybe I could ship this overseas. And I'd say, okay, wait, hold on. This is a great line of reasoning. We should definitely be planning for the future, but there's a lot of hurdles to get rid of oversupply overseas and things that we should definitely think about, including the fact that the overseas market in the EU is already compressed out the gate. Because remember, they have supply coming in from everywhere, Canada, Thailand, pretty much South America. And then you have to have EU GMP standards, which is way out of my pay grade. I do not live in that world. I think Anne might be able to speak to that, or Hirsh might be able to speak to that a little bit more as far as international oversupply and where we live there.
Totally. Thanks for that, Rachel. That was actually right where I was going next. So appreciate that. So I'm going to build on some of what you said. And then after that, I'll have a question for you, Ian. I just want to touch on what Rachel was talking about, international commerce. We were just talking about interstate commerce. Now let's talk about international commerce. If you wanted to be an optimist about international commerce, you would say, I looked at the Blanche order and there's language in the Blanche order that talks about export permits. The international market is opening up. And it's like for interstate, there is some encouraging language around an export market. But here's the way that I would put it. Moving medical cannabis from Schedule 1 to Schedule 3 removes one key barrier to exports for sure, but it does not make for a seamless export market. I think that's the way to think about it. Yes, it is much easier to export a Schedule 3 than a Schedule 1 drug, but there are still complications. So the most important thing to note is that in this international regime, you will be subject to the UN Single Convention of 1961, which is a really complicated document, but it specifies certain things, such as you can engage in exports, but it has to be for medical or scientific purposes, which is how Canada is able to export to Germany. In addition to that, it requires there to be like some central federal regulator, for example, in place as Canada has in order for that regime to take place. So that's important. And then there are other things that are notable as well. If you want to export to other countries, you'll have to obtain an import permit from those countries. That's like a document that needs to be obtained in order to export in the first place. So that's quite important. And then there was what Rachel mentioned, which are GACP and EU GMP requirements. And I'll just state flatly, like a majority of cannabis that is grown in the United States does not comport with the EU GMP standards that exist in Europe. Just a crude way of putting this is German regulators are really strict and they're getting even stricter. So it's fine to have dreams of export. And I think this does open up the world in which there's more of an international market on cannabis. But just to emphasize again, moving from Schedule 1 to Schedule 3 removes a really important barrier to exports, but there are GACP and EU GMP requirements. You often need to obtain an import permit from the destination country, and this exporting needs to happen for medical or scientific purposes. And so those are all the thorny questions to talk through when it comes to exports. I'm going to switch quickly and I'm going to ask Ian a question, switching away from this international market. You and I talk all the time about these federal changes and obviously the banking and compliance world really well. And you're familiar with all of the banking hurdles that exist and the hurdles that exist to payments, for example, and the lack of credit cards in the space. And one thing that you have always told me is it's going to be a while before a lot of those things changes. Rescheduling won't open up banking overnight or payments overnight. But what if I were to say, but medical cannabis is now federally legal. And as a federally legal business, again, assuming I don't have any adult use activities, I'm just running a great business in Kentucky, or I'm an operator that only has facilities in Florida and Pennsylvania, I'm purely medical. If I'm a federally legal business, what stops me from doing the following, like listing onto major stock exchanges, obtaining SBA loans, obtaining the benefits of bankruptcy, being able to work with banks, normal IP protections, being able to be acquired by non-cannabis entities? For these medical operators that are now apparently federally legal, can I operate as a normal business vis-a-vis the banking and the payment system? What do you say to that?
That is a really great question. I still believe, like we've talked about, where rescheduling is not going to change anything overnight per se for access to banking or proper payment systems. But in general, it will absolutely move those things forward. Just this greater acceptance and this understanding that this is not a Schedule 1 drug anymore. And we've had a ridiculous approach for decades now. That's all starting to change. And we see that. I think that we will see more banks choose to get into this space, and there's not a lot holding them back at the moment. It's just, they just are reticent to come in, but I think we will see more and more banks coming in. And as more banks come in, we're going to see more payments infrastructure start to arrive. So I do think it is moving the needle in that direction, but I wouldn't expect anything to happen very fast. Now, this is a fascinating question about medical, because you're absolutely right. If everybody's medical from start to go, why can't you walk into Bank of America and open up a checking account? And why can't you call up a low-risk credit card processor and say, I want to set up credit cards in my shop? It seems like you should be able to do all those things. And I guess we'll probably see people start to challenge those boundaries and start demanding their full access, if you will, because they're medical. So I think we'll see what happens in that regard. But I like the momentum for sure.
Totally.
I also want to cue up Ian as the mayor of cannabis in Europe. That's his colloquial name. That's what we call him. So what are you seeing on the ground in Europe? And tangential to what I said, let's not just try to start exporting out there. What's the market? Just something to that effect.
Europe, definitely watching what we're doing. I just got back from Berlin with you, of course, Rachel, a couple weeks ago, and we hadn't had the news yet on rescheduling. We were just still riding off of the previous news was that rescheduling was coming. So hard to say what the feeling is over the last week that we've seen these changes, but it will be a minute before you see too many American companies exporting, medical companies, presumably exporting into places like Germany. To Hirsch's point, you need to hit GMP standards, which is a good manufacturing process. You need to have facilities, clean rooms, contamination, documentation, record keeping, staff training, hygiene, equipment validation, quality control, batch testing, supply chain traceability. All of this is going to have to come into play if you want to go play in Europe. So you're going to have to meet all the European qualifications there. So it's probably going to take American companies a few minutes to figure out where their lane is for being able to export, but I'm sure it's coming.
Awesome. Thanks, Ian. Next, we're going to talk about the hearing that'll take place in June and July for adult use cannabis. And similarly, I'm going to offer some observations on that, and then I'm going to tee up a question for Rachel and see if she agrees with my perspective here. As you guys know, we just talked a lot about the legalization of medical cannabis, but there's adult use operators, and folks know by now that there will be a hearing that starts on June 29th that runs to July 15th. It'll wrap up 3.5 months from now. That will consider what is being described as the full rescheduling of cannabis, or the rescheduling of adult use cannabis. And so I think the question on people's minds are like, okay, so this hearing's going to end on July 15th. What happens then? And what does it mean for 280E? And does that become retroactive? And so I'm going to give you my takes on these questions. So the first thing is the hearing will wrap up on July 15th. Nobody knows for sure if the Attorney General is going to come out with an order a month or 2 months or 3 months from then. But I think it's important to note that the Attorney General, Todd Blanche, the same guy who issued this order last week, has the authority, no matter how that hearing goes, to issue his finding on adult use cannabis. So that's giving a lot of people confidence that adult use cannabis will also be rescheduled. We can't say that for sure, but people believe that's extremely likely. The other thing to note is a lot of the CEOs that are most connected to this process, folks like Boris Jordan or Kim Rivers, have been very plugged in on the rescheduling conversation. They have stated publicly that they expect rescheduling of adult use to happen in Q3, certainly by the end of the year. Could they be wrong? Absolutely, they could be wrong. But is that a useful data point for people to keep in mind as we think about the rescheduling of adult use? I think it's a useful data point to keep in mind. A third thing I'll flag is, like many things in our country, this is largely political. And so we all know the midterm elections are coming up. And so that's one thing for people to keep in mind. Is this something that the administration is going to want to peg as a win, knowing that it's in their full control of the Justice Department going into the midterms? That seems like it could be the case. The final thing that I'll note here is, if you think about medical operators, a lot of medical operators are incumbent, maybe like MSO operators who have been in the industry for a longer period of time, more well-capitalized operators. A lot of the newer operators to the industry are adult use operators or are social equity operators who receive their licenses relatively late. So the question is, will that bifurcation stand, knowing that the preferential tax treatment of medical licensees will in large part benefit larger MSO incumbents, and a lot of these newer licensees or adult use operators? Will we continue to live in a world in which the medical operators get those tax benefits and the adult use operators don't? I think that's going to be a hard political sell, right? If I'm a regulator in California, for example, and I had this big sort of social equity program that I leaned into, and a lot of these were adult use operators, I'm going to want to make sure that those operators get the same benefits that these medical incumbents would. Or if I take New York as an example, where the incumbent operators, the large MSOs are medical, but the newer operators are adult use. I know that was a lot there. Those are basically a series of, none of them definitive, but I think useful things for you to keep in mind about whether adult use will also be rescheduled in a timely fashion and receive that preferential 280E tax treatment. So none of us on this call can say by August 12th or August 18th, the rescheduling of adult use will be finalized. But I do think we have some clues that we can look at about whether we expect this to happen, right, in an expeditious fashion. And so, Rachel, with that caveat that I just offered, that like we can't predict when it's going to happen, but let's just say for discussion purposes, we felt it was pretty likely that it was going to happen, right? Like in the few months following the hearing. And I'm sure, Rachel, you were hearing from people who are saying, oh, do I redo all of my operations to make everything medical because the medical operators are getting the benefits? I don't want to lose out. Do I revamp my operations and become medical overnight? I've talked to state regulators who have said, we're going to make it easier for a lot of these operators to get a medical designation because we want them to obtain the benefits. So state regulators seem to be mindful of the fact that they don't want to lock their licensees out of this. Does it concern you at all if we thought the rescheduling of adult use cannabis would in fact happen? Would you have any caution about someone redoing their operations entirely to become a medical operator? Or how do you think about that just at a high level?
I guess if we think about 280E is Internal Revenue Code, Section 280E. Now, have states conformed to 280E or have they not conformed to 280E? So when we think about how states are going to operate with regards to what U.S. Treasury ends up doing and whether it's retroactive or only going forward, a lot of states said we're not going to conform to 280E. Although it exists on the federal level, the federal tax return is done one way. It has a 280E implication. The state tax returns, where the states don't conform to 280E, is a different type of tax return. You can deduct all ordinary business expenses. So if I think about what you just said, Hirsh, are the states going to conform or not conform? They're probably going to mostly fall in line and mostly conform. Do I think that the IRS is going to allow people to go ahead and amend 3 years back of tax returns or more? I would just say, and I'm sure other tax professionals on the phone would agree with me, we have a hard enough time filing amendments for tax returns and getting the IRS to accept 1 year, 2 years, 3 years. It takes them at least a year to even address it. They have very little staff. So I'm just looking at the practicalities of, are they going to go retroactive? I could see the IRS and U.S. Treasury saying, no way. There's no way we want to do this. Don't give us a whole bunch of work that we don't need, nor can we support all of this work. So I highly doubt it, but that's my crystal ball coming out. And the next thing I'd say is any kind of amendments, if that's the case, if people want to start taking different positions on 280E, regardless of whether this is supposedly retroactive or not retroactive, and you can go back 3 years. It's not infinite number of years. Another thing to consider is filing protective claim for refunds. I guess we could do that right now as well on any kind of retroactive tax years that you're filing. Protective refund claims can allow you in this kind of uncertain situation to protect your ability to get a refund or amend your tax return in the case of these uncertain times. So these are two things that I would definitely consider.
Thanks, Rachel. Thanks for that. I'm going to make a couple of comments. One, we'll touch on this issue that Rachel just mentioned, which kind of gets into dual licensees. And then the second main thing I want to cover is what is the implication of rescheduling for state level reform and for international markets? I'm going to try and hit those two topics in the next 5 minutes or so, and then hopefully we can leave a few more minutes for questions or anything else that Ian and Rachel want to say as we wrap up here, knowing that there's so much more we could talk about. The first thing that I wanted to cover is what Rachel was getting into, which is, I think, a common question, which is a dual licensee. This is super complicated. How is this going to apply to me? And there was the example Rachel gave of like an operator in California that has like a medical and an adult use license. Here's what I would say. There is like high level, I just think helpful things to keep in mind right now. And then there's the guidance that will be forthcoming. At a high level, I think it is logical for us to all say that you want to ensure that your books can distinguish medical from adult use activity. And I hear what everyone is saying. I'm in California, medical is like 4% of my sales, et cetera. That's all fair. But I would just first say at a high level, it probably will be useful for you to see the best and most logical way that you can clearly like bifurcate that activity. I think that's a good preparatory step to take right now. But the second and more important thing I would say is guidance on this will be forthcoming. So as mentioned before, the Department of Treasury and the IRS put out a document that explicitly said, we understand that it's really complicated. The accounting, the tax differences between medical and adult use is complicated. And we're going to be putting out guidance on this shortly. A different way of putting this, they're still figuring out in real time as well. And without disclosing any specific conversations, as someone who has been in touch with state regulators and has heard about their conversations with the DEA, I really want to emphasize the DEA included and state regulators, they are figuring this out in real time. And don't just take my word for it. If you look to the Nevada Cannabis Compliance Board, for example, they put out a statement saying, we're still trying to figure out how this will work and further guidance will be forthcoming. So I think the takeaways, guys, are like, number one, it probably will be useful to find some way to bifurcate and clearly distinguish medical from adult use activity. That's a good step we should be thinking about. But I think we can expect further guidance to come from the IRS and Treasury. I think many of us who have been working in this cannabis space for 7, 8, 9 years, we've come to believe like the government's never going to give us clarity here. And I share their skepticism. But in the weeks since this order has come out, like different departments of government have been issuing press releases and indicating that they are aware of this. If you go to the DEA website right now, on one of their main homepages is this registration portal. So clearly the other branches of government are aware of this thing that the president has done and are responsive to it. When the Department of Treasury and the IRS puts out a press release saying, we're going to give you guidance soon, I think they mean it. There's much more we could talk about the complications of how that'll work in practice, but I would mention those things. I would also say again, a lot of this stuff becomes moot if rescheduling of adult use happens as we anticipate on schedule later this year. So yes, we should all be thoughtful about making sure we claim all of the medical benefits we can, but we should also be cognizant of the fact that if this all gets rescheduled, then a lot of these things that we're worried about may ultimately become moot. These are all different thoughts we have to hold in our head at the same time. The other main point that I wanted to make is we should be thinking about how rescheduling impacts both state level reform and international markets. And this is more of a medium term thing, right? Those of us on the call, I think a lot of us hope that 5 years from now, we are still working in cannabis and that this is a thriving industry that has grown even more robust. I think all of us hope, aside from what we need to get done in the next month or 2 or 3, that over the next 2 or 3 or 4 years, that this will become a global industry. And here's where I think we do have good news. And I think that good news is twofold. One, there are 10 states that lack medical cannabis programs. Already in those 10 states that lack medical cannabis programs, we are seeing signs that number could get smaller or much smaller in the coming years. So just to give you an example, by May 12th, the Georgia governor has a deadline about whether to sign a medical cannabis expansion bill. If he does, then Georgia will become the 41st state to legalize medical cannabis. There's currently a ballot initiative that is collecting signatures in Idaho. If it gets on the ballot in November and passes, Idaho could become the 42nd state to pass medical cannabis. The governor of Indiana came out yesterday and said, look, we're surrounded on all sides by Ohio and Michigan and Illinois. And now Trump just did this rescheduling thing. Like, we should finally pass a medical cannabis program. A really conservative Republican governor. You could see Indiana move. The North Carolina governor has a commission to study the implementation of medical cannabis. There is a law in South Carolina on the books that people weren't really paying attention to that says if the federal rescheduling of cannabis changes, then the state rescheduling has to change with it. So I just gave you 5 examples of 5 of the 10 states that don't allow medical cannabis: Georgia, South Carolina, Indiana, Idaho, and North Carolina, that already have momentum to move. So I think what we should be paying attention to is the development of more of these medical markets. And we've already seen in places like Kentucky and Alabama, these markets that are just getting off the ground, that they could end up being pretty formidable. So that's worth paying attention to. This could also affect adult use debate. I think the best example of this is Pennsylvania, where the Republican Party holds the Senate in Pennsylvania, and they basically said, we won't pass an adult use bill until cannabis is removed from Schedule 1. Cannabis has been removed from Schedule 1, and now there's a lot more pressure being put on these legislators to continue a move there. And importantly, in a lot of these states, it's Republicans that have been the obstacle here and that have held power. And now that Donald Trump has taken this move, that could sway them. So it's important to pay attention to what are the state level opportunities that are going to come to fruition over the next 1 to 2 to 3 years as a result of this? And I think it's going to be a lot. The final thing I'll say is just big picture. If we all zoom out, this is a big world of 8 billion people. The world often takes its cues, for better or worse, from the United States on drug policy. Cannabis was legal for most of American history, but in the early 1900s, the United States had this insane idea to make it illegal, and then the rest of the world followed. It's important to note that the whole world is watching. Europe is watching. Countries in Africa are watching. Thailand is watching. And so I think we can all be optimistic that the United States taking this step has been heard around the world and can start to open up international markets. And will you have an amazing export business next month? I think my bad news is probably not. But do you have the potential to establish a meaningful global footprint over time if you want? I think the answer to that is yes, knowing that these things take years to play out. Although this rescheduling order is not perfect, it has unlocked a logjam that has existed both at the state level in this country and internationally. And I think that's what we all have to look forward to in the years ahead.
One thing that I will point out that I know we're all aware of is that rescheduling doesn't change any of the social issues that we are all very acutely aware of. Social equity, expungement, people are not getting out of jail because this got rescheduled. So nothing is changing on our social issues. But going back to what Hirsh said a moment ago, this really is a global movement and the world is watching and they are paying attention. And I think we're going to see other countries and other regions of the world expanding their, okay, well, let's take a look, because America is not telling us that this is what they were telling us for the last 100 years. So I think we're going to see global movement come out of this moment.
I love that, Anne. Do we mind if we open it up for Q&A? I see Nate has his hand up. And then we also had Lauren had a really good question that I'm getting asked quite often. Lauren was asking, should we be scared or reticent to register with DEA? I've gotten a number of those questions by text today. Are we opening ourselves up to a new level of scrutiny? I'm gonna just say a couple things on that real quick. If we think about the 8300s that we've all had to file, and what website do we have to get on to register in order to register to file the 8300s and less paper filing? The Financial Crimes Enforcement Network. Essentially, that is one of the websites that we have to sign up on in order to get our registration to e-file the 8300 forms for cash. So we should be quite familiar with these types of tracking, methods of tracking and systems and things like that. I'm not saying that we should be okay with all of this type of tracking, but I would probably say it's something like that. What would you say, Hirsh?
I agree with all that. I will just say this. I understand people's apprehension about submitting a form with the DEA. And I think there are some people that are properly concerned because there are some pretty intrusive questions in that application. I think the first thing for everyone to do is, if you haven't reviewed those questions, you can go on to Marijuana Moment and review the questions. I think it's important to consult with a legal professional to determine if there's any liability you might incur by answering those questions. Consult with your attorney. But just know that if you're a medical operator, availing yourselves of the benefits of being a legal business will ultimately require that DEA registration. I'm not giving anyone legal advice, but that's important to note. And it's important to note that a lot of well-known operators have already begun submitting that information. So above all, I think it's important for you to consult with a legal professional on whether you feel like you're incriminating yourself by answering that or in any legal jeopardy, but that's some relevant context that you should be aware of.
My question is, in California itself, and every state has their own Controlled Substance Act. In California, cannabis is still Schedule I, and it's like that in many other states. Do you feel like that can add another layer of complication, or they have to reform it?
I think in some ways, yes, in some ways, no. I'll just say, although cannabis is still like Schedule I in California, California has taken steps like untethered state level 280E from its cannabis regimes, right? So it has taken steps to treat it more as a normal business. And I'll also say, without speaking for any state regulators, they have not highlighted that as a real obstacle to availing yourselves of the benefits of rescheduling. So I think this is one of these things, Nate, where we're going to have to wait and see. It's a good call out. It's something we should be aware of. But in practice, I don't view that as being an obstacle to obtaining the benefits of rescheduling. And if it turns out to be, I think you can anticipate the state, especially in California, to reform that pretty quickly.
Hirsh is available to answer any kind of regulatory intelligence questions. I'm here to answer any tax questions. Ian is here to answer all kinds of cash and payment banking questions.
Banking, payments, worldwide cannabis movement.
So Hirsh, if somebody were to reach out to you, what kind of questions would they ask you as an operator? Because I know there's a lot of nuance here.
I think it's a lot of these questions that we're talking through today, and our team will be in touch about the logistics of how we kind of set that up. But it would be like, as we talked about, these laws vary tremendously between different states, right? So I'm in this particular state. What are the relevant state laws that I should be aware of? And in addition to these different federal laws, what are the different things that I should be paying attention to as this kind of unfolds? Is there FinCEN guidance that I should be paying attention to that might impact banking? I would say similar to a lot of the questions we talked about here today.
Awesome.
Stay tuned for our second webinar. And of course, if you have any questions that you would like us to touch on as things continue to develop, feel free to email us at info@verdantstrategies.com, and we will make sure to either touch on them within the live webinar coming up or within the next episode of the Cannabis Brief, which is linked on our YouTube as well. Thank you all for attending.